Tracy Darrell Adkins versus Rhonda Forlaw Adkins.
Your Honors, my name is Chuck Blackard. I represent Mrs. Forlaw along with Jonathan Pledger in this matter. I'm pleased to be here and looking forward to making this argument. In this matter, I would like to reserve 5 minutes.
All right, sir. You may proceed.
Divorce case. Parties married 5/11 of 1997, 3 children. Divorce filed in 2014. And very different procedures took place. I am the 4th set of lawyers representing the wife and mother in this matter. And it appears to me that most all of the documents,
before you get too deep in your argument,
sure.
We've reviewed the briefs. We certainly haven't reviewed the record because the record's too voluminous. But I'm perplexed how where we are right now when all this seems to have transpired several years ago. How does this court have jurisdiction at this juncture? Neither one of the briefs addresses the procedural history, and perhaps there's a reason for that, but I need to know what jurisdiction we have at this juncture and what we're working on.
Your Honor, it's a good question, because if there is any normalcy to domestic cases, this is very abnormal. As a result of a divorce action that was filed in 2015, there was an MDA that was entered in 2015. Then what happened, just as a matter of fact, the proceedings were protracted, delayed, preventing them from being a final order. There were other matters that were engaged to be heard, and I have to say I don't believe that I would have chosen that path at all. Nevertheless, what happened, that this matter has been brought up to the Court of Appeals on ancillary issues involving this case more than three times at least, and I think there was attempted 4th time. But what that caused to happen is that the path that was chosen, the trial court judge, very good judge, not that a judge has to be a friend of yours, but I've been in front of him very often, respect him. He's brother of the judge in the last case, this case in Williamson County with Judge Mike Binkley. There became an effort to have him recused as judge. It was almost like an obsession to have him recused, and the previous lawyers, to myself and counsel, that's what they were all engaged in. And when I first looked at this case, I saw the voluminous boxes, and what is going on with this case?
I think there are about 60 of them.
Excuse me?
I think there's about 60 technical records.
There is, but regardless of what the parties have stated, where they are in odds, there's a procedure. I've been practicing, not that it matters, but long enough, 42 years, doing domestic cases. In cases that deal with irreconcilable differences, engage the parties to enter into a marital dissolution agreement. And we've had some guidance on that. We've had some guidance recently with Barnes, went from the Court of Appeals to the Supreme Court, and then also cases of onset. But those cases are different than this case. They can be distinguished very easily. Both Barnes and both Olson, which were enforcing MDAs, also had to find a ground for divorce was present in those cases. This case, very, very odd. It took a previous case and expunged it using a statute that was not intended to be used that way. The statute was for the purposes, if the parties reconciled, you could ask the court to expunge the record, dismiss the case, expunge the record, and it would be done. For whatever reason, it seemed more appropriate that the counsel at that time involved decided that would be a good procedure to follow, and they would start anew. But what happened, I believe and respectfully submit to the court, that when they started anew, they failed miserably because the complaint for divorce, as filed for the husband, alleged no ground for divorce. Primarily, what it was attempting to do was to enforce an agreement, a marital dissolution agreement, that had been executed by and between the parties. What I would hope that the court understands, and I believe that it does, is very important that there's a third party to every divorce, and that's the court. The court is the entity that passes on your agreements and to find that they are fair and equitable. And the court has the power and the ability, and rightfully so, to say, I don't like this agreement. I don't like what you're doing. I want you to go back, do something else. But also, the way that our law has been set up regarding statutory waiting periods, there with children, it's a 90-day waiting period. Without, it's 60-day waiting period. Why? Why would we do that? Because this is a very important aspect of our society, that you need to make decisions based on not heat of the moment, passion, but have reflection time. And our own law requires us to do that. In this case, what happens is, and we do not apologize for it at all, there was an agreement that was reached on the third day of mediation. There were 3 separate days of mediation. And in that third day, the wife signed an MDA. And then she refused to file a divorce. Why? Because one thing, she didn't believe that her situation was irreversible. She didn't believe that she couldn't salvage her marriage. So what happens? The husband files. Alleges no grounds. Not one ground. Says we are proceeding under the marital dissolution agreement, and the marital dissolution agreement is predicated on irreconcilable differences. The number 1 paragraph in the marital dissolution agreement states that the wife shall be awarded the divorce. The court does not award the wife a divorce. The court awards the husband a divorce, and there is no grounds alleged or proven in this case. It is predicated on a statement that the parties have irreconcilable differences.
That contained in the MDA?
Yes.
Why does that not suffice?
It says that the wife, let me clarify that. It says the wife shall be awarded a divorce on irreconcilable differences. It doesn't say that the parties shall be awarded a divorce. When the wife decides that she does not want to pursue this divorce anymore, there becomes a very interesting segue into, can she retract, rescind, repudiate? Some cases say no. They say no because there's a ground proven. In this case, there's no ground proven. Also, the court, and I know I'm under the yellow light, there is this particular judge granted a partial recusal on an issue, and it went to another judge. And we respectfully ask this court to consider, once the judge has found that he has a recusal on one issue, he should be recused of all. There is no other case that deals with a partial recusal in the state of Tennessee. Respectfully yield my other time to my co-counsel. And thank you.
Thank you.
May it please the court, Larry Hayes of the Nashville Bar on behalf of Tracy Adkins, the appellee, along with my co-counsel Rachel Thomas, who's sitting at counsel table. Your Honor, this case
Before you get in too deep, Mr. Hayes, why don't you try to tell me how we're here, why we're here, and how we got here? Because I'm still
we got here
perplexed.
through a tortured history of pleadings, Your Honor.
That seems obvious.
It began, for Rule 3 purposes, by the entry of the final decree, which the court called a memorandum of opinion on January 7, 2017. After that, Ms. Adkins filed a motion to recuse in February because she didn't like the ruling. This court denied that, went up on a 10B. After that, she sent a subpoena, wanted the court clerk, the judicial assistant of the judge, to testify, filed a motion to compel her to testify. That's the issue on which Judge Binkley recused himself for that motion only. That's what the order says. And it's just a series of motions after motions after motions. But the final decree was entered January the 7th, 2017. It was subsequently amended, I believe, later in January or early February. But after that, it's just a series of motions to alter, amend, motions to recuse over the next 7 years. I mean, we've been, or 6 years, we've been dealing with the same issues over and over and over.
Well, that's what I'm trying to ascertain is that the date, and is everybody in agreement that that never became final?
I do not believe it ever became final.
Because of a series of motions to
Series of
amend?
perpetual motions. In fact, the wife tried to come up to this court before on a Rule 3 appeal, and the court opined that it's not final, and it sent it back down. After which Judge Binkley ruled, are there any other issues y'all can identify? We identified a few, he ruled on those, and now that brings us to this court at this point. So I believe we are still, as amazing as it seems, appealing a Rule 3 on a January 7th, 2017 final decree. To get to the meat of the matter, though, the argument that the judge did not have the authority to enter this divorce is just wrong. TCA 36-4129 says very plainly, and the judge cited this on page 51 of his opinion, the court may, upon stipulation to or proof of grounds for divorce, do one of two things: grant the party less at fault of divorce or declare the parties divorced. Now, the court heard proof of grounds in this case, and that is at the transcript. If the court wanted to look at it, pages 312 to 313 of the transcript. The court heard the wife testify about how the husband called her the C word, 4-letter word I'm not going to say. Every other name in the book, a pompous 5-letter word that starts with B. Testified about his drinking, his rehab, a secret pornographic tape that she made without his knowledge. I mean, there is a mountain of evidence. Exhibit 4, Exhibit 5 are both pleadings that were filed in the first case. Scurrilous allegations. There's a mountain of evidence in this case about grounds. And TCA 36-4129 is very clear. If the court hears any proof of grounds, it can declare you divorced or award a divorce to the party less at fault. And that's what the court did here. Awarded Mr. Adkins a divorce. And as this court well knows, there is a presumption on appeal that a final decree is supported by the evidence. That's the Farrar case, Farrar, 553 Southwest 2nd, 741. The wife has done nothing, absolutely nothing, to try to overcome that presumption. other than make some procedural arguments. On page 14 of her brief, she argues that irreconcilable differences is a consent judgment, that it requires the consent of both parties at the time. I mean, that is all pre-Barnes argument. That was superseded by Barnes. This court said so in Olson versus Beck. Also again in Polster 2021, Olson versus Beck in 2015. I mean, that issue is dead, whether it a consent judgment. It is not a consent judgment. Under Barnes, it's treated as a contract. That's what Judge Binkley viewed this case as, and he found she had no contractual defenses, even though she raised a myriad of them. The condition precedent argument, once again, Your Honor, much has been written, as you can well imagine, by Corbin and the restatement of contracts on what is a condition precedent. They're disfavored in Tennessee. That's the Harlan versus Hardaway case that we cite on page 37 of our brief. And any doubtful language about whether it creates a condition precedent is treated as not a condition precedent, but simply a promise. You need specific language, and we know what that language is, provided that, if, only if, as soon as, or when. That language is not in the language that was cited just now about how the wife shall be awarded a divorce. I mean, that's simply stating what everybody anticipated was going to happen, except for the fact that she then changed her mind, which is undisputed. Paragraph 2 of the MDA indicates that it's the party's intent that this MDA will be incorporated into a final decree. Paragraph 28 indicates that the parties agreed that this MDA would be introduced into a divorce proceeding. And if the court wanted to see what a condition precedent looks like from the party's perspective, it's paragraph 46. We've got two conditions precedent in that paragraph. The agreement shall take effect only upon both parties signing and having their signatures notarized. That's a condition precedent. Neither party shall be bound until they both sign it and it's notarized. Again, a second condition precedent. Wife shall be awarded a divorce is not a condition precedent. Finally, on the partial recusal issue, I submit first and foremost the wife has waived that issue. And that's supported by Olson v. Beck, which is...
Has that issue not been litigated in the other recusal issue?
It has been raised in the other recusal, 10B appeals. However, Judge Armstrong said in the most recent one that the wife could raise that argument again in a Rule 3 appeal. So if we assume this is a Rule 3 appeal as we first started discussing, then I submit it is possibly ripe had she briefed it or argued it or cited any authority to support the argument. But she did none of that. And I would refer the court to Olson versus Beck, where it talks about skeletal arguments, that this court is not obliged to make the argument for the litigant, not obliged to research the argument for the litigant. I mean, she cites no authority. She cites nothing in the record. She mentions that that's an issue as issue 7 in her brief, but then the closest she comes to making an argument about it is in the conclusion of her brief, where she just says, partial recusal is unheard of in Tennessee. I mean, that's the sum and substance of her entire argument. So I submit first and foremost, she's waived the argument. If she hasn't waived the argument, though, I think the context of the partial recusal is important because the case was tried to conclusion in April of 2016. There was a letter with a USB that I sent to the court that had the trial transcript because the court wanted it, copied opposing counsel. In January of 2017, as we started discussing, the trial court entered its final decree and ruled against the wife. February, she files a motion to recuse, still in 2017. Then in May 2017, this court issued Adkins Opinion 1, I call it. And then in July of 2017, we're 6 months after the final decree's been entered, she, the wife, sends a subpoena to the judge's legal assistant wanting to get testimony and documents from her. Then on August 2017, she files a motion to compel Ms. Rubenstein to testify. And that's where, and what she asked in that motion, if you want to look at it, it's at the record 3,752. And it says that she wants to compel Ms. Rubenstein to explain how and where a pleading called trial transcript was obtained by Judge Binkley. I mean, are we serious? Is she really filing that? Because if you look at the record 3,639, they have a copy of the letter I sent them, or sent to the judge, that said, Judge, in response to your request, here is the entire trial transcript. And by copy of this letter, I'm alerting opposing counsel that I'm sending this to you. I mean, and they had the original trial transcript. I had to get a copy. And so, but they're filing a motion in August of 2017 trying to act like they don't know what the judge is looking at. And it's been like that for 7 years, Your Honors. That's why it has taken so long. At the record at 3986 is where the judges recuse themselves, all the judges in Williamson County, because Ms. Rubenstein obviously associates with all of them. And they say in that order that it is for one motion only. It's very specific. And it makes sense because it's the judge's legal assistant. It was sent to Judge Parks. He ruled correctly, I believe, that compelling Ms. Rubenstein to testify would invade the judicial deliberative process privilege. So he denied the motion in its entirety. That's in the record at 4617. And that order from Judge Parks was never appealed. So I believe it's the law of the case at this point. But once that issue was eliminated, Judge Binkley came back into the case and finished it out. So it's really not a recusal issue.
Was there objection to Judge Binkley finishing the case out at that time?
There were probably 6 or 7 objections, all motions for complete recusal. Motion for, I mean, that issue was litigated over and over and over.
Has that issue been up on appeal? That particular recusal issue? Is that the one Judge Armstrong dealt with that you
It has been up, but it has not been definitively ruled on because Judge Armstrong indicated that issue was waived in the third 10B. However, there is language in the Adkins opinion too that says she's free to raise it in a Rule 3 appeal. So Here we are. But, Your Honor, they cite no authority for their proposition that it's unheard of. I will submit I can't find any cases in Tennessee on it. We could find plenty of cases in the federal system. The Sixth Circuit Decker case that we cite says in Decker that the majority view is that partial recusals are favored, as you know, especially when you're dealing with an ancillary issue. And they say that, citing an Ellis case out of California, just because on an ancillary issue a judge may step back, as with the Rubenstein issue, and say, I don't need to be hearing this because the perception of impropriety. It doesn't mean you have to throw out everything the judge has done, especially in this case when you're looking at everything the judge has done in the past tense. This motion was filed in August 2017. He had already ruled, he'd already heard the case in April 2016, he'd already entered a final decree in January of 2017. And that's why we're here, for him enforcing the MDA and awarding Mr. Adkins a divorce. And we also cite the Matthews case of our sister state in Arkansas, one of the few state cases we could find. But you know, unless the court has any other questions, I'll conclude by saying, you know, wife has intentionally delayed this case and the approval of these agreements for going on 7 years now. I mean, her actions are not supported by the facts. Her actions are not supported by the law. But her actions do support a pretty strong rebuke from this court. And that rebuke should be affirming everything Judge Binkley has done and awarding Mr. Adkins all of his attorney's fees. Thank you.
Thank you.
Good morning, Your Honors. Jonathan Pledger on behalf of the appellant, Ms. Adkins. Wanted to give a preliminary note. Me and Mr. Blackard got involved in this case in August of 21, well after all these motions to recuse and petitions and the various things. To respond specifically to Mr. Hayes, Judge Binkley did not enter a fault-based divorce. He entered a divorce based on irreconcilable differences. It is our contention that a divorce based on irreconcilable differences is a consent judgment. It requires the consent of both parties. That's what I believe footnote number 2 in the Barnes case is saying. And if I can quote that.
Let me ask you a question here.
Yes.
What are you really saying about this irreconcilable differences divorce? You've got a MDA, as I understand it, that says we're going to get a divorce. It's going to be irreconcilable differences. The divorce is going to be awarded to the wife. That generally correct?
That's fair to say, Judge.
Then the problem would be, as I understand it, the trial court awarded the divorce to the husband. Is that correct?
Judge, I think it's a little more complicated than that, if I could explain.
Okay.
As in both Barnes and Olson, you had signed MDAs. You had complaints based on irreconcilable differences. In the Barnes case, the husband withdrew his consent. He said, no, I don't agree to irreconcilable differences. And that's what the Supreme Court in Barnes is getting at. The court ended up awarding a divorce based on fault, inappropriate marital conduct, and then enforced the MDA. The Supreme Court in Barnes made a point to say the court did not enter a consent judgment. It first found fault, entered a divorce based on fault, and then entered the MDA. So I think it's more complicated. And to talk about the MDA for a second.
Well, let's talk about this particular instance. Why? What makes this different?
Well, the difference is, Judge, this MDA was signed under a prior divorce proceeding. That MDA refers to this.
So what?
Because that MDA refers to this pending divorce, this divorce. It's referring to a particular pending divorce action.
Okay.
And I think there's also some room to differentiate this from Barnes. Barnes, the MDA in Barnes contained a very important paragraph. And so if we're going to compare MDAs, the paragraph in Barnes said, the parties agree that this MDA, subject to the court approval, shall be incorporated in and made part of any decree of divorce. That's a far stretch from the MDA in this case. The MDA in this case did not say this MDA will be used in any future divorce. The MDA in this case said this is for this pending divorce, which was a case that's now expunged. So I think there's a big contrast between MDAs between this case and the Barnes case. In addition, the Barnes court brought up the issue of, is irreconcilable differences a condition precedent to the enforcement of an MDA? The Barnes court unfortunately said it was not raised at the trial issue and would not answer the question. So I think that question still exists. It is our position that an ID divorce is a condition precedent to the enforcement of an MDA. And I think the Tennessee policy behind divorce supports that. Mr. Blackard said earlier, we have a 60-day waiting period and a 90-day waiting period. If once you sign an MDA, that's done, why have the 60-day waiting period and the 90-day waiting period? Let's just have a contractual divorce. We're getting pretty close to a no fault. Once you sign, you're stuck with it. I believe the policy of the Tennessee divorce policy is that an MDA can be retracted, can be rescinded, and it is a condition precedent to the enforcement of an MDA.
Didn't the trial court deal with that specific issue?
It was raised in our Rule 60 or 59 twice, and the court disagreed with us.
And what was the basis of that ruling?
If I remember, Judge, it was, I cannot tell you if he addressed it other than denied it. I think he just denied the motions outright.
Let me ask you, wasn't it contemplated that after the MDA was agreed to, that the original divorce was going to be dismissed, and this MDA was going to be used, and the new divorce would be filed? And for that reason, on the MDA itself, it didn't show the docket number for the original divorce action?
I've got 3 seconds. Can I answer the question?
Sure.
Okay. That's a good question, and you are correct that the MDA did not show a docket number. However, I would submit that the attorneys who drafted that MDA were smart attorneys. They knew about Barnes. They knew how to draft a contract, if you want to call it a contract, that would have incorporated, we're going to dismiss this current divorce, we're going to refile. All of that would have been contained in that MDA. That MDA was not drafted by Ms. and Mr. Adkins. It was drafted by Mr. Hayes and Ms. Rogers. So I think exactly what you're saying, that would have been contained within the MDA.
So, was it contemplated that the first
That is what they,
divorce was gonna be dismissed?
I believe
and
the
the
here,
MDA was gonna be filed, and the divorce that was gonna be filed after the dismissal of the first, or not? That's what I'm trying.
I believe Judge Binkley took that up in the hearing in April of 2016, and that is how he ruled. But that is not within the terms of the MDA, no. But that is what
You're
Judge
just saying
Binkley,
there was no language.
There's no language in the
that
MDA.
set that out.
correct.
Okay.
All right, thank you.
Thank you, Judge.
Thank you, counsel. We appreciate your argument, appreciate your briefs. We will endeavor to get you an opinion on this matter, hopefully resolving it at the earliest possible time. And we will